Welcome back to the deep dive. We're here to sift through the sources, basically giving you that shortcut to getting up to speed instantly.
That's the goal.
And today, well, our source material is a bit different. It's a blueprint, really. An introductory script for what sounds like a, well, incredibly ambitious content series.
Yeah, it is ambitious. We're not looking at a finished product, but the plan itself.
Exactly. So this deep dive isn't about what has happened, but we're analyzing the foundational promise, the whole concept behind a project aiming to, maybe, redefine legal history.
That seems to be the aim. We're digging into the framework for true courtroom stories based on judgments. And it's explicitly authored by Zahir Ahmad Mir.
Right, so our task today is pretty specific. We need to unpack the grand narrative strategy he's mapping out here.
Understand the sheer scope. I mean, it's vast, covering centuries, continents.
It really is.
And try to get a handle on the, let's say, the deeper philosophical definition of justice that's implied by putting all these different legal systems side by side.
Okay, let's get into that. Because if you look right at the opening line he's written, it immediately sets the tone, doesn't it? It raises the stakes way beyond just, legal analysis.
It does, that foundational hook.
Every judgment is not just a decision of law. It is the turning point of a life, a family, or sometimes an entire nation. Just that phrase, turning point. Wow.
It's powerful. It tells you straight away, this isn't just about the legalese.
No, it suggests something much more dramatic, much more human than just reviewing statutes.
Absolutely. If the script just said a judgment is a decision of law, well, that would be interesting to some, maybe a niche legal audience.
Sure, dry, maybe academic.
But framing it as a turning point. The author, Zahir Ahmad Mir, he's promising something bigger. He's promising we'll explore the ripple effects, the societal, the emotional, the political consequences of that decision.
So the legal system becomes this engine of human drama, almost destiny.
Pretty much. That's the hook, isn't it? It guarantees that you, the listener, whether you're a lawyer or just curious about real stories, you'll likely stay engaged because the stakes feel inherently human. High stakes.
Yeah, it's that promise that we won't just learn what the ruling was, but we'll feel the human weight behind it. The conflict, the harm, the real need that forced that ruling into existence.
Right. The why behind the what.
Getting that blend of sort of high-stakes emotion and serious intellectual rigor. That's a tough balance.
It really is. And that balance seems key to the title he's chosen. True Courtroom Stories. It's positioned as a unique podcast looking at the stories behind landmark judgments.
Okay, so for this whole concept by Mir to actually work, these cases can't just be any old case. They have to be resonant, right? Universally significant somehow.
That's the implication.
Yeah.
And that brings up the first challenge. What actually counts as a landmark judgment when you're looking globally across history like this?
Good point. Because for the series to deliver on its promise, these rulings need to do more than just settle one specific argument between two people.
Exactly. They need to carry significant societal weight, real consequence. We're talking about cases that maybe redefine fundamental rights or overturn ways society has operated for decades, or establish entirely new legal principles.
Like those moments when a court ruling becomes, as the blueprint puts it, an inflection point in history.
Right. And that implies the judge or the court did more than just apply the existing law. They actually shaped the future direction of their society.
It's also important, I think, that we know who's behind this vision. It's clearly attributed to Zahir Ahmad Mir.
Yeah, that matters.
So the choices made, which courts to include, which to leave out, how the stories are structured, these aren't random. They reflect his specific idea, his conceptualization of what makes for compelling legal storytelling and maybe even universal justice.
Indeed it does. It immediately makes us ask, okay, if he's pulling examples from such a, frankly, dizzying range of cultures and times, what's the common thread? What fundamental unifying idea of jurisprudence is he actually searching for?
That's the million-dollar question, isn't it?
It really is.
And that question, that search for unity, it leads us straight into our first big segment here, because the scope outline, it's not just broad, it's monumental.
Oh, absolutely. Monumental is the right word.
We're not just comparing, say, common law and civil law traditions, which is complex enough.
No. It's way beyond that. We're talking vast geography, North America, Europe, the subcontinent, and then leaping back over 1,000 years in legal history. That's a massive undertaking.
Huge. Editorially, narratively, how do you even begin to connect those dots?
Well, that's the profound challenge, isn't it? And the success of this whole series idea really hangs on how skillfully it can handle that juxtaposition.
Yeah.
Putting modern, complex, codified legal systems right alongside foundational, ancient jurisprudence. It's essentially setting up a global compare and contrast of justice itself.
Okay, let's break it down, starting where many listeners might feel maybe most grounded, the Western sphere. The script explicitly mentions the Supreme Courts of USA, UK, and Canada.
Right, the common law, big three in many ways.
So what's the implied link there? What connects their legal battles beyond just being, Western democracies?
Well, the core connection is that shared heritage, the common law tradition. These are legal systems built fundamentally on precedent, on stare decisis, the idea that courts should stand by decided matters. So when Mir groups them like this, I think he's highlighting the kind of ongoing constitutional and societal debates that are characteristic of modern liberal democracies. The cases he'd likely focus on here probably grapple with those inherent tensions, individual freedoms versus state security, for example.
Or how foundational documents get reinterpreted over time.
Exactly. Like the U.S. Constitution or maybe the unwritten constitutional conventions in the U.K. How do those adapt? The focus will probably be on common constitutional issues, civil rights advancements, maybe precedent-setting commercial disputes that shape modern capitalism.
So if common law emphasizes precedent, the turning point in these places often happens when a court actually breaks from precedent or dramatically rereads it for a new era.
Precisely. Or when a completely new issue arises that the old precedents just don't cover.
What kind of modern challenges might the project look at in these courts then?
Oh, well, think about things like the evolution of privacy rights in our digital age. That's huge. How do Fourth Amendment protections designed for physical searches in the U.S. apply to your emails or your metadata?
Right, that's a constant battle.
Or you could look at Canada and the ongoing discussions about the scope of charter rights. Or, in the UK, the Supreme Court's role in navigating Brexit, balancing parliamentary sovereignty with judicial review. These are really complex, sophisticated legal fights.
So the narrative here is likely about how these centuries-old legal systems are stretching, adapting, sometimes struggling to deal with brand new technologies and changing social values.
I think that's exactly it. How established principles get tested by modernity.
Okay, that makes sense for the common law sphere. It's about the pressure of the new on the old. But then the blueprint takes this sharp turn, geographically and perhaps conceptually.
It really pivots, yes, showing that the quest for justice isn't confined to this sort of Anglo-American bubble.
It moves dramatically to the subcontinent's dramas, specifically mentioning the dramatic battles in the courts of India and Pakistan. That feels different.
It is different, profoundly different legal and social landscapes, even though both India and Pakistan inherited a version of the common law framework because of their colonial history with Britain.
So what makes the legal fights in India and Pakistan distinctively dramatic compared to, say, the more predictable, maybe, workings of the U.S. Supreme Court? What's the unique pressure there?
I think the core difference lies in the sheer intensity of the balancing act these courts perform. They're operating under immense pressure dealing with issues of national identity formation, incredibly rapid economic and social shifts, and the huge challenge of governing deeply diverse populations with varied traditions.
Okay.
So their big legal battles often sit right at that really sensitive intersection where secular constitutional rules meet deeply embedded cultural norms or distinct religious personal laws.
So the drama isn't just like a stylistic choice for the podcast. It's inherent in the legal problems themselves. It's baked right in.
I think so, yes.
Right.
Exactly. You're looking at potentially huge constitutional questions over things like land reform or the rights of religious minorities or major pushes for things like a uniform civil code in societies where personal life, marriage, divorce, inheritance might be governed by separate religious laws for different communities.
Oh, okay. That's complex.
It is. So a landmark judgment in India might be something related to the basic structure doctrine, the idea that Parliament can't amend the Constitution in a way that destroys its fundamental identity. That's huge.
Right.
In Pakistan, the drama might revolve around the judiciary reviewing actions of the military or political leaders, or navigating the very intricate relationship between Islamic principles, Sharia, and the modern state statute law.
So the focus shifts. It's less about fine-tuning existing rights within a stable system and more about the courts actively participating in defining the very nature of the state itself through their rulings.
Yes, I think that's a good way to put it. It's a much more dynamic, sometimes volatile environment where a single judgment really can shake society overnight, fulfilling that core promise of the series, the turning point idea.
Okay, that tension, legacy, modernity, diverse cultures definitely provides the dramatic narratives Mir seems to be looking for. But then comes the biggest leap of all,
The most ambitious synthesis, yes, and maybe the most conceptually challenging.
taking us all the way back to the timeless Islamic legal precedents of Prophet Muhammad P. and the Rightly Guided Caliphs. That's a massive jump in time and legal culture.
It is. And this inclusion, I think, is really the critical clue to the author's underlying vision.
How so?
Well, it strongly suggests that Zahir Mir sees modern legal decisions, no matter how complex or secularized, as part of a much longer, continuous, cross-cultural human effort to establish fairness and order.
Okay.
By bringing in foundational Islamic jurisprudence decisions for the 7th and 8th centuries, he seems to be searching for the primal, maybe universal building blocks of justice. What are the absolute fundamentals?
It's a fascinating contrast. I mean, how do you even begin to connect, say, a 7th century ruling about a disputed well or debt repayment, decided perhaps relatively simply by a qadi, with a massive multi-million-dollar corporate liability lawsuit in modern Canada involving layers of complex statutes?
Well, the connection presumably isn't necessarily in the specific facts, but in the underlying principles of jurisprudence.
Ah,
Early Islamic legal tradition, the Sharia and its interpretation through fiqh, developed a really sophisticated framework. It built extensively with concepts that are fundamental to any legal system, anywhere, anytime,
like what, for example?
like clear rules of evidence being what constitutes proof, how many witnesses, what caliber of witness. Also, ethical conduct in contracts and commerce, that's a huge part of fiqh. And the role of the judge, the qadi, is often conceived not just as someone who applies rules, but as a facilitator of truth, reconciliation, and fairness, sometimes even mediating rather than just ruling.
So the idea is to look past the specific historical context and focus on the method used to find truth and achieve fairness, especially when you don't have a massive modern library of statutes and case law to rely on.
Precisely that. So let's say a modern U.S. court is grappling with the reliability of expert scientific testimony in a complex fraud case. The series might then pivot back and ask, how did early Islamic jurisprudence handle conflicting witness accounts? What were the criteria for testimony to be considered unimpeachable, adala?
Interesting.
It suggests a search for those sort of timeless ethical guidelines that should ideally govern how humans resolve disputes, regardless of whether the system is common law, civil law, or rooted in religious tradition.
This allows the author, Mir, to ask some really profound questions then. About the universality of justice itself. Are the core problems needing reliable evidence, striving for fairness, dealing with bias, are they truly constant across millennia and vastly different societies?
That seems to be the core intellectual project here.
And for you, the listener, this really delivers on that desire for multiple deep perspectives. It provides the broadest possible historical and cultural background to modern legal issues.
It's definitely an editorial high-wire act, though, a huge challenge. You have to avoid making simplistic comparisons or just cherry-picking examples that fit a preconceived notion.
Sure, the risk of anachronism or misinterpretation is high.
Exactly. To successfully link these incredibly diverse legal systems, the series would need to convincingly demonstrate that the foundational wisdom or the structural approach from, say, a caliphate ruling still has genuine relevance to the constitutional debates happening in the U.S. today, or the social upheavals being addressed by courts in India. That's the real test.
Okay, so that sets up the vast scope of stories, but now we need to look at the how. How does Zahir Mir plan to distill these huge, complex legal histories into, say, a compelling narrative format? That brings us to segment 2. Looking at the courtroom itself as a clear, almost archetypal narrative structure.
Right. And the blueprint he provides is actually quite methodical about this. He lays out 4 pillars for each episode's story: conflict, evidence, arguments, and the final judgment.
A classic 4-act structure, almost.
Pretty much. And it works because it mirrors how we naturally process stories and seek resolution. It takes potentially dense legal material and shapes it into something accessible, even dramatic.
Let's start with the first pillar, the trigger, conflict.
Conflict is essential. It's the human starting point, isn't it?
Oh.
It's the source of the drama, the betrayal, the injury, the financial ruin, the abuse of power, the constitutional violation, whatever it is.
It's the why we care.
Exactly. By focusing on the raw conflict first, The series immediately grounds the subsequent legal stuff in real human stakes. If you, the listener, don't feel the weight of that initial conflict, why would you care about the intricacies of the evidence or the arguments?
Right. It's the necessary hook before you get into the mechanics of the law.
It is. The conflict is what forces the issue into the courtroom in the first place.
And once it's there, the legal machinery kicks in, leading us to the second pillar, evidence. This feels like the shift towards objectivity.
It is. Evidence is the intellectual pivot.
Hmm.
The narrative moves, hopefully from subjective human feeling and accusation towards verifiable facts, or at least attempts at verification.
Okay.
In the context of these landmark judgments that Mir wants to focus on, the evidence presented is often the thing that blows the case wide open. It might expose a huge societal problem or reveal a truth that was hidden. Think about whistleblowers or DNA evidence or forensic accounting breakthroughs.
So the evidence phase is where the true part of True Courtroom Stories gets established.
Ideally, yes. The collection, the presentation, the challenges to evidence this is where the factual basis of the story is built, brick by brick. It links that initial human conflict to the formal legal process.
And once those facts are on the table, or at least the contested versions of them, we get to the third pillar, arguments. This is the battle of interpretations.
Right, the intellectual wrestling match. Arguments are crucial because they showcase the dynamism of law. They show how two intelligent, trained people, the lawyers, can look at the very same set of facts, the same evidence, maybe even the same statute, and come to completely different conclusions about what it all means and what should be done.
That's key for the listener, isn't it? To understand that law isn't just a math problem with one right answer.
Absolutely. It's a discipline of interpretation, persuasion, rhetoric, logic, all brought to bear on those facts. The argument segment is where the abstract legal principles are forced to grapple with the messy reality brought out by the evidence. It's the clash of legal theories.
And that clash leads inevitably to the final pillar, the resolution, the core of the whole premise, the final judgment.
The judgment is the necessary endpoint. It's the moment where all that abstract argument translates back into concrete reality. It is the turning point that the series promises, the decision that changes lives, impacts families, maybe alters the course of a nation.
It's not just the answer to the legal question posed by the conflict.
No, it's more than that. It's the official, institutional decision on what happens next. And critically, in landmark cases, the judgment often sets the very precedent, lays down the new rule. That gives the case its landmark status for the future.
Now, one thing I found really interesting in the blueprint was the intended delivery style. It explicitly promises to tell the story in a way that feels like you are sitting right there on the witness bench. That's a very specific, immersive viewpoint. What does that add?
I think it's a deliberate tactic to create a sense of enforced proximity, maybe even responsibility, in the listener.
How so?
Well, if you're just getting a detached third-person summary of a case, it's easy to stay distant, academic. But if the narrative puts you metaphorically on the witness bench, you're suddenly closer to the action. You're positioned to feel the tension in the room, to really listen to the testimony, to weigh the evidence as it's presented, maybe even feel the scrutiny of the lawyers and the judge.
So it's trying to move the listener from passive reception to more active critical engagement.
That seems to be the goal. You're encouraged to listen as if the outcome matters to you personally. It transforms it from just learning about a case to almost experiencing the process, which could be particularly effective when dealing with these complex, cross-cultural legal stories. It makes it more visceral.
And underpinning this whole structure, this immersive approach, is that strong statement from Zahir Ahmad Mir again. These are not fictional tales. These are true courtroom stories based on judgments. That claim of truth seems vital.
It's absolutely vital. It's the project's intellectual anchor, its claim to authority, especially when you're making comparisons across centuries and cultures from the U.S. Supreme Court back to the Caliphate. Well, accuracy is non-negotiable.
You can't just wing it.
No way.
Yeah.
By promising that the core facts, the conflict, the evidence, the main arguments are sourced directly from official final rulings, Mir is assuring the audience. He's saying, you're learning based on the validated historical record, not on rumor, not on media spin, not on some screenwriter's imagination.
It ensures the drama serves the facts, not the other way around.
Exactly. It gives the whole enterprise credibility.
So that structure, conflict, evidence, arguments, judgment, all sourced from real rulings, told immersively, that's the formula. It's the aha moment. It connects a deep historical context with immediate human drama and assures the listener it's all grounded. In fact, you get the whole arc. Okay, let's pivot now to segment 3. The intended impact and connecting with the audience. A project this ambitious needs to really demonstrate why it matters now. Why should you, the listener, care about a ruling from 18th century Britain or 8th century Medina?
Right. Relevance is key.
And the script addresses this directly by promising cases that did one of three things. They shook society, defined justice, or sometimes even rewrote history. These feel like distinct categories of impact.
They are distinct, and I think they function as the criteria for why a particular case gets chosen for the series. For Zahir Ahmad Mir's concept here, a case probably needs to hit at least one of these benchmarks, maybe more.
Let's break them down. First, cases that shook society. What does that imply?
Shook suggests an immediate, powerful, maybe visceral public reaction. It implies a rupture, a sudden disturbance in the social fabric, or perhaps a profound collective moral reckoning.
So very public, very immediate consequences.
Often, yes. These are likely the cases that deal with highly sensitive issues. Maybe matters of public morality, where the court ruling goes against prevailing sentiment, or exposes deep political corruption, or reveals catastrophic failures by the state or corporations. Think major civil rights breakthroughs that cause backlash, or environmental disasters where liability is assigned, or huge corporate fraud scandals.
Things that make headlines and dominate conversations.
Exactly. They force the public to confront an uncomfortable truth about their society or their leaders. The change they provoke often comes through public outcry, media attention, and immediate political pressure that follows a ruling.
Okay, so the impact is primarily societal, maybe emotional, and often fast. What about the second category? Cases that define justice. That sounds foundational.
It does. Defining justice implies something more lasting, more principled. These are the rulings that bring clarity where there was confusion or ambiguity in the law. They establish a standard, an ethical or legal template for how similar situations should be handled in the future.
Can you give an example?
Sure. In the common law world, think of a judgment that clearly delineates the boundaries of police power or establishes a really robust standard for what counts as informed consent in medicine, or clarifies the meaning of equality or due process under a constitution. These rulings don't just solve the one dispute in front of them, they provide a kind of compass for navigating similar issues down the road.
So it's less about the immediate shockwave and more about the long-term intellectual and systemic clarification, setting the rules of the game more clearly.
That's a good way to think about it. The societal shake is immediate, emotional. The definition of justice is more intellectual, systemic, and enduring.
Which brings us to the third, and maybe most profound, promise: cases that rewrote history. That's a huge claim.
It's the ultimate benchmark, isn't it? Especially given the global and historical scope Mir is proposing. Rewriting history implies a fundamental, permanent, structural change that alters the trajectory of a nation, or even an entire legal system.
So we're talking about really foundational shifts.
Absolutely. Given the courts mentioned US, UK, Canada, India, Pakistan, these could be decisions that directly lead to constitutional amendments, or rulings that dismantle entire systems of segregation or discrimination, or judgments that mandate massive government reforms, or ones that fundamentally alter the balance of power between branches of government or between the state and its citizens.
So, thinking about the subcontinent examples again, a history rewriting case, there might be a ruling that establishes judicial review so strongly that it permanently changes how politics works in that country.
Precisely. It creates a new, lasting institutional reality. Or, if you look back at the ancient Islamic precedents he wants to include, maybe a foundational ruling that codified a principle, like the protection of property rights or the necessity of hearing both sides in a dispute. Principles that then spread and influence legal thinking across vast regions for centuries. These are the kinds of legal turning points that historians simply have to include when they explain how things changed. Non-negotiable milestones.
Okay, the ambition is definitely there, connecting these different levels of impact, immediate shock, defining principles, lasting historical change. But who is this really for? Who is Zahir Ahmad Mir targeting with this incredibly comprehensive project? The call to action seems very broad. A lawyer, a student, or simply someone who loves real stories of truth and justice.
Yeah, that inclusivity seems crucial to the whole concept, and it actually helps explain some of the structural choices we talked about, like the four-pillar narrative. It looks like it's deliberately designed to appeal to two distinct, though potentially overlapping groups.
Okay, let's take the first group, the lawyer or the law student. What's the specific value proposition for them in this kind of deep dive?
For them, it's essentially offering a sophisticated comparative legal education, but in an engaging format. They get the technical depth because the focus is on actual judgments, evidence, and arguments. But crucially, they get this across, what, 6 very different legal traditions and historical periods.
Right. US, UK, Canada, India, Pakistan, and foundational Islamic law.
Exactly. I mean, where else can a student primarily focused on, say, American constitutional law, quickly get accessible insights into the major structural debates facing the Supreme Court of India, or understand the historical roots of evidence rules found in early Islamic jurisprudence? It's offering specialized knowledge combined with unique comparative perspectives. It could really broaden their understanding of what law even means.
Okay, so it offers breadth and comparative insight for the legally trained. What about the second group, the general enthusiast, the person who just, as he says, loves real stories of truth and justice?
For them, the structure is key. That conflict evidence arguments judgment framework we discussed makes it accessible, because each story starts with the raw, relatable human conflict.
The emotional hook.
Right, and then it moves step by step through the evidence, the facts, before it gets into the potentially complex arguments. Well, that means the listener is eased into the legal complexities. They're not just thrown into dense jargon from the start.
So the law is always anchored in the human story.
Exactly. It helps translate potentially abstract constitutional concepts or ancient legal principles into compelling narratives about real people and real stakes. It makes the complex digestible.
So this carefully designed structure, as laid out by Zahir Ahmad Mir, it really aims to deliver on that promise of being a shortcut to being well-informed about some pretty complex global and historical legal stuff. You get the human drama, you get the historical sweep, you get the legal analysis, and it's all supposedly validated by the official court record.
That seems to be the package deal he's proposing, yes.
Okay, as we wrap up this deep dive into the blueprint, let's try to synthesize this vision. What Zahir Ahmad Mir has outlined here is, well, it's a highly structured, seemingly immersive journey across vast stretches of legal history.
Yeah, and the core goal seems to be uncovering or at least exploring the common threads of justice or the persistent problems in achieving it that might connect different cultures and different eras. It's an effort to maybe democratize access to this history and humanize the often intimidating face of law.
That's a good point. What's really striking, I think, is how this framework positions law. It's not presented as just a dusty set of static black and white rules you look up in a book.
No, not at all. It's framed as a dynamic, ongoing, often dramatic process. A process of human conflict, investigation, argument, and finally resolution, however imperfect that resolution might be. The series seems to suggest the real value isn't just knowing the outcome, but understanding the process of how we, as societies, reach a judgment and the profound changes that can flow from that process.
It definitely forces you to recognize that maybe the core struggles are constant. Whether you're looking at an ancient Islamic ruling about witness reliability or a cutting-edge U.S. Supreme Court case about AI and bias, maybe the fundamental human challenge of defining right and wrong and ensuring fairness just keeps recurring in different forms.
That seems to be the underlying thesis. The ambition is to show humanity wrestling with the same core ethical and legal dilemmas throughout recorded history, just in different contexts and through different legal lenses.
The author's specific choice of jurisdictions, that mix of West, subcontinent, and ancient Islamic roots, ensures that the series is constantly setting up those comparisons, showing different cultural attempts to solve universal problems.
Powerful comparative engine, if executed well.
Which brings us to a really interesting final thought for you, the listener, to maybe ponder. Given this incredible range that Zahir Ahmad Mir proposes from those foundational Islamic precedents right up to today's Supreme Court battles in the West, if we accept that the goal across all these systems fundamentally is justice, what single element of the legal story structure he outlines, conflict, evidence, arguments, or judgment, do you think is the real turning point for society?
That's a tough one. Is it the raw evidence that comes to light, shifting public understanding and forcing change?
Or is it the brilliance or persuasiveness of the argument that reframes the law itself, creating new possibilities for the future?
Or is it simply the brute force of the final judgment, the decision that has the immediate power to alter lives and institutions, regardless of the elegance of the argument or the clarity of the evidence? Which part truly rewrites history?
It makes you think about where the real leverage for change lies within the legal process. Is it in establishing facts, shaping interpretations, or wielding authority?
It probably varies case by case, but it's a great question to consider.
And perhaps related to that, you could also reflect on which of these diverse legal traditions mentioned today, the common law systems of the US, UK, Canada, the dynamic constitutional courts of India and Pakistan, or those ancient foundational Islamic precedents, which one might hold the most surprising or maybe the most unexpectedly relevant stories for your current understanding of law and justice today.
Because based on this ambitious blueprint laid out by Zahir Ahmad Mir, it seems the potential for surprising connections and fresh insights is meant to span every single one of those cultures and eras.
Definitely something to think about. Join us next time for another deep dive.